All right, good morning, everyone. It is Thursday, November 17th, 2022, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Commissioner Gomez? Commissioner Wilson?
Here.
Commissioner Wood? Chair Madich?
Here. We'll go ahead and proceed to item 1, public comment for items not on today's agenda. Do we have any public comment under item 1?
Hello?
Hello?
Yes, this is Steve Petzold down in Santa Clarita, California. I miss meeting with you more regularly. I am calling because I still have some outstanding cases that seem to be taking a long time. That's 2017-00998 against Michelle Jenkins, 2018-01386 Larry King, 2020-00351 Yes on Measure US. And I also would like to make inquiry. I know you can't answer a question, but 2019-00135. That was commission initiated, and that's against Big Bad Bonds. They seem to be taking a long time, and I would like to see the cases resolved as quickly as possible. Thank you.
Thank you, Mr. Petzold. Do we have any additional public comment under item 1? Hearing and seeing none, we'll proceed to item 2. This is a closed session personnel matter. The commission will now adjourn into closed session and reconvene.
a word missing, and since we're approving them, I thought I would mention it. Probably should say Commissioner Baker stated she supports, just says Commissioner Baker states supports. It's a minor typo, and with that one change, I would move to approve.
Sorry.
Yeah, I went, but that page 5, 1, 2, 3, 4, 5 lines down, there's a new paragraph. Commissioner Baker stated supports some
Oh,
of,
I see.
I just think it's she supports, minor
Right.
thing. Probably should have just pointed it out in advance, but thank you.
All right. Any other questions or comments for item 3? Hearing and seeing none, I will make a motion to approve. Do I have a second?
Second.
Any public comment on item 3? Hearing and seeing none, Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Gomez,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
All right, we'll now move to our consent calendar. Today, the consent calendar consists of items 4 through 7. Do any commissioners wish to pull an item from the consent calendar for separate discussion? Going once, going twice. Hearing none, I will move approval of the consent calendar. Is there a second?
Second.
I can,
Any public comment on the consent calendar? Hearing and seeing none, Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Gomez, Commissioner Wilson,
Aye.
Commissioner Wood,
aye.
Chair Matich.
Aye.
The motion passes.
All right, we'll proceed now to item 8. This is assignment of hearing to an administrative law judge in the matter of Hanford Now and Dan Chin. And I will welcome Chief of Enforcement, Ms. Brereton, to the table. There's no commission action required here unless we want to hear it ourselves, if I understand that correctly.
Good morning. Yes, that is correct.
All right,
So we are recommending that this matter be heard before an ALJ as per our usual procedures. We usually, well, as you know, this is a 2016 case. So we really want for, the most efficient resolution as we can reach with this matter. So by recommending that an ALJ hear this matter alone, and then we present a proposed decision to the commission, we believe that that is the most efficient way moving forward. It would require us to coordinate scheduling with only the respondents and the ALJ, as well as our enforcement staff. It would be more efficient in that the ALJ will hear the entire matter. Typically, the cases are set and scheduled for a full day at a time. The typical matter begins at 9, is scheduled until 4:30, 5 o'clock in the evening. It will go as many days as is necessary for each of the parties to present all of their evidence, and then for the opening and closing arguments and all of that. So we believe in these circumstances that it is the most efficient resolution for an ALJ to hear this matter alone and then have a proposed decision presented to the commission for final decision.
thank you. That certainly makes sense to me. What's the timeline currently with scheduling these hearings with the Office of Administrative Hearing?
The Office of Administrative Hearings I haven't looked at the calendar today, but recently it's usually between 2 and 3 months out, but it depends on the length of time of the hearing. And I have not conferred with my staff on this about how long we think our side will take, and then, figuring out how long the respondent side will take and all of that. So we don't have an estimate yet.
Okay, thank you. Do other commissioners have questions or comments on item 8? Commissioner Baker?
Thank you. So just to clarify, so the efficiency is that, because otherwise you'd be coordinating with 5 commissioners, their schedule, and there's going to be a hearing, and just having the one person would make it go a little bit faster. That's the primary time savings, I guess I would say.
That's correct. And the ALJ has to be there regardless. So the ALJ will always be present whether the commission hears the matter or not.
Good, thank you.
Any further questions or comments, Chief Brereton? All right, thank you, Chief Brereton.
Thanks.
Appreciate it. We'll now proceed to item 9. This is adoption of proposed amendments to Regulation 18624, lobbyist arranging gifts, 18625, loans to lobbyists or lobbying firms, and proposed Regulation 18626, contingency fee prohibition. And with us this morning is Mr. Lau, pinch hitting for Mr. Woodside.
Chair and Commission, good morning. I'm here recommending adoption of proposed regulations involving lobbyists. These regulations were submitted to the Commission for pre-notice discussion at its September Commission meeting. And as you may recall, we are recommending the adoption or amendment of 3 separate regulations, which I will discuss in turn. The first of these is Regulation 18624. The Act prohibits lobbyists and firms from making and arranging gifts to certain officials. The proposed regulation would clarify when a lobbyist arranges a gift. In short, the current regulation defines a lobbyist when a lobbyist is unlawfully arranging a gift as opposed to a permissible gift from a lobbyist employer. As determined in a prior commission opinion, lobbyists are not arranging for a gift if they are merely making a recommendation or providing information to their employer. However, this language was not incorporated into the current regulation, and this proposal will clarify the long-standing commission opinion by adding that standard expressly into the regulation. Do we want to have questions on each one as we go, or just save them to the end?
Why don't you go ahead and
Okay.
continue?
The second of the regulations is Regulation 18625. Under the Act, lobbyists are prohibited from placing an official under a personal obligation. Interpreting this restriction, the existing regulation prohibits a lobbyist from extending a loan to an official. Proposed language would further clarify that the prohibition on placing an official under personal obligation extends to a lobbyist who fails to make sufficient efforts to collect payments owed to them by an official for services provided by the lobbyist. As proposed, a lobbyist fails to make sufficient efforts to collect past due payments if the lobbyist does not follow the process provided for in the contract, does not follow their typical process used in their regular course of business, and does not attempt in good faith to use their best efforts to collect the debt. Additionally, under proposed subdivision D, lobbyists that have, say, otherwise not made sufficient efforts can avail themselves of a safe harbor. Under this provision, a lobbyist can remedy any kind of failure to collect if they pursue a legal action within 6 months of the month the unpaid services were provided, or 6 months from the date the official is elected if the payment is contingent on the election. Since and in response to the pre-notice discussion, several changes have been made to the proposed safe harbor provision. First, for simplicity, we have removed a requirement to send a demand letter. It's not that we think they won't send a demand letter, it's just that once they start the legal action, our view is that that is sufficient evidence that they fully intended and are attempting to collect the debt. And the demand letter was just like an extra requirement that didn't need to be provided for in the regulation. Second, as suggested by the commission, language to extend legal action to include a compelling a formal arbitration process has been provided. And third, we provided a clarification of the 6-month timeline to initiate the legal action. And just to clarify that it's the last month on which the unpaid services were provided is when the 6 months begins, not the end of the services, whatever those services happen to be. So they can't just kind of extend out the services to get over the fact that they're not collecting for 6 months ago. Moving on, the last of the proposed regulations is 18626. Under the Act, lobbyists and firms are prohibited from accepting or agreeing to accept any payment contingent upon the outcome of a legislative or administrative action. This proposed regulation simply clarifies and further defines that this means any payments and provides several examples of types of payments, fees, bonuses, salaries, commissions, and then clarifies that it's any degree contingent. I mean, it's not, if dependent at all on any kind of degree, then that's contingent. So that's all this regulation is attempting to do. Turning to public comment, the commission has received a letter of support from the Institute of Government Advocates. And in response to public comments received at an interested persons meeting, we've clarified in the memo that the prohibition on contingent payment does not apply to lobbyist activity outside California. With that, staff proposes the adoption of the proposed amendments, and I can answer any questions you may have.
Thank you, Mr. Lau. Let me just say, I think staff has done a very nice job incorporating the feedback we gave you at the pre-notice stage. So I don't have any questions. I think these are well-crafted and worthy of our support, but let me open it up to my colleagues. Any questions or comments for Mr. Lau? Commissioner Baker?
Thank you. Thank you also for incorporating our feedback from before and working this out. The two questions I have are pretty minor. We did request that legal action be beyond, filing a lawsuit. It could be arbitration. I just wanted to make sure, there's lots of dispute resolution options. Sometimes they go to mediation. Do you feel that the language that is in here now is not just limited to filing a lawsuit and going to arbitration, allows for other private mediation services with the definitions that you have? Because I would want to make sure it does.
Yes, civil action and the arbitration are provided as two examples. So it does say legal action. We are looking for a degree of formalities to make sure that there's clear intention of collecting the debt, but there is some room for interpretation as far as what would qualify as the legal action.
Great. And can you clarify for me if a consultant, let's say somebody's a consultant and they're thinking about legal action and they're doing the math and it's going to be more expensive and they decide it's not worth it to do legal action, what would be the appropriate way for that to make sure that they're not in a position of holding something over the elected official, like they're forgiving a debt?
This goes back to the general test, which is whether or not they're following their typical procedures and whether or not they're using their best efforts. So if they make the determination, and it's a reasonable determination, that pursuing legal action is going to be too costly and more than what they would collect, then it's perfectly within their best efforts and within their typical procedures to erase, to consider that not really forgive it, but to not pursue it. Correct. Yes.
But that would be reported, presumably, in some way transparently, that somehow it would be reported that accrued expenses, I don't even remember what category it would be in, have been forgiven, so that it's transparent in the public that a debt, essentially a debt that, or financial responsibility has not been pursued further. I'm looking at what the transparency of that would be. And I may be hitting you with the question instead of Mr. Bainbridge or someone else, but
Mr. Bainbridge is reaching for his.
He's going for the
my thought is these are typically for services other than lobbying, so I'm not positive that they will end up being disclosed on a lobbyist report.
Yes.
From the campaign.
Yeah.
Oh, right. Okay. Yes, the official would be required. Okay. I was looking at it from the lobbyist perspective. Yes. From the official perspective, yes, the official would be required to report.
Got it. So that would be somehow on their regular reporting forms. I'm looking at the chair, but I just want to make it clear it's going to be transparent when this happens. It's not an under the table agreement, or it shouldn't be. Yeah.
Any further questions for Mr. Lau? All right. I will move approval of the regulations as presented by staff, item 9. Do I have a second?
Second.
Can I interject before you vote? Commissioner Wood, I believe, is having trouble with her audio. So if she could give a thumbs up or thumbs down for her vote, so we have it clear on the record that how she's voted.
Can you not hear me now?
We cannot hear you,
Okay.
Commissioner Wood. So,
There's the
you can hear
delay.
us. All right. All right. Is there any public comment on item 9 before we proceed to a vote? Hearing and seeing none. Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Gomez?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood? Chair Matich?
Aye.
The motion passes.
All right. Thank you, Mr. Lau. And thank you to Mr. Woodside for his very good work on this as well. We'll now proceed to item 10. This is In Re Kendrick opinion. And with us today will be Commission Counsel Kevin Cornwall. Morning, Mr. Cornwall.
Morning, Chair and Commissioners. Just get right into it. In September of this year, the Governor signed into law SB 1439. The bill was unanimously passed by the legislature and aimed at combating pay-to-play or quid pro quo corruption and the appearance thereof. The bill amends Section 84308 of the Political Reform Act, which was first enacted in 1982 as the Levine Act, and limits certain public officials from taking part in licensing, permitting, and other entitlement for use proceedings if the official has received a contribution exceeding $250 from a party or participant in the proceeding within the previous 12 months. It also prohibits officials from receiving a contribution from a party or participant for 3 months after the official took part in the proceeding involving the contributor. From the time the law was first enacted up until SB 1439, the scope of 84308 was fairly narrow, excluding local elected officials, generally applied in the limited context of placing a prohibition on an appointed official taking part in use entitlement proceedings when that official was also running for another office. This was in part because the catalyst of the Levine Act was a Los Angeles Times report that several coastal commissioners in appointed position had solicited and received large campaign contributions from persons who had applications pending before the commission. With SB 1439, the legislature has chosen to amend Section 84308 and extend its prohibitions to local elected officials, with the author noting that the problem of special interests seeking to influence local decision-making is long-standing, well-documented, and real. As an example, the legislative history noted a 2016 Los Angeles Times investigation that found donors linked directly and indirectly to a real estate developer gave more than $600,000 to Los Angeles officials vetting an apartment project. After SB 1439 passed, we began receiving several questions as to how Section 84308 would apply, specifically with respect to whether its look-back provisions would apply to contributions received or proceedings conducted throughout 2022. In preparing for this meeting, I also received some data from our enforcement division. Sorry. So after SB 1439 was passed, we began receiving several questions as to how 84308 would apply, specifically with respect to whether its look-back provisions would apply to contributions received or proceedings conducted throughout 2022. Staff has reviewed the comments that we received regarding this agenda item and has received and appreciates the input from the regulated community as they raise points that bear consideration. The most common concern expressed in the comments and also addressed in the memo is that a look-back period extending into 2022 would constitute retroactive application of a law or implicate constitutional ex post facto concerns. However, the cases in the memo demonstrate that courts have considered retroactivity in a variety of circumstances and consistently held that application of a statute is not retroactive merely because some of the facts or conditions upon which application depends came into existence prior to its enactment. Rather, California courts have determined that retroactive application of a law occurs when a law attaches new legal consequences to an act that was completed before the law's effective date, such that the relevant question is whether the last act necessary to trigger application of the statute occurs before or after the statute's effective date. As discussed in the memo, no official would violate Section 84308 based on conduct that occurred in 2022. Rather, an official would violate Section 84308 based on subsequent conduct occurring in 2023, such as taking part in a proceeding for which they have received more than $250 from a party or participant, or accepting a contribution exceeding $250 from a party or participant to a proceeding that the official took part in within the past 12 months. Because the last act necessary to trigger application of the statute would occur after Section 84308's effective date, it does not constitute application of the statute and, in fact, constitutes prospective application from a legal standpoint. With this in mind, the appropriate question isn't whether the legislature included any language giving retroactive effect, but whether the legislature included any language indicating an intent to delay the effect. With regard to some of the questions regarding ex post facto, or whether this is permissible retroactive application, I think some of those comments miss the distinction in that that is essentially the second question that is to be asked. The first question is this retroactive application? And I believe the cases that we include in the memo demonstrate that it isn't an instance of retroactive application, but considering all of the comments that we received that sort of missed this distinction, I continued to research the issue. I came across another case in which the California Supreme Court states, in general, application of a law is retroactive only if it attaches new legal consequences to or increases a party's liability for an event, transaction, or conduct that was completed before the law's effective date. Thus, the critical question for determining retroactivity usually is whether the last act or event necessary to trigger application of the statute occurred before or after the statute's effective date. A law is not retroactive merely because some of the facts or conditions upon which its application depends came into existence prior to its enactment. Another comment that we received noted that a 1983 Commission Regulation 18438 specified that Section 84308, as originally adopted, did not apply to contributions received prior to the statute's effective date. I've reviewed our file for Regulation 18438, and there isn't any indication of the Commission's rationale in adopting that regulation at the time. The file itself is obviously approximately 40 years old. It references some earlier material, but there isn't any memo or anything that specifically discusses the rationale in adopting that approach. The only real mention of the background of the regulation is that the Commission had received several questions about how the new statute would apply. So with that in mind, it seems that the 1983 Commission was likely faced with some of the same questions the Commission is considering today. However, with the benefit of 40 additional years of case law and retroactivity, if that was a concern for the Commission in 1983, I think any potential concern about that has since been clarified, such that it shouldn't pose the same concern today. And if the Commission based its regulation on considerations of the burden placed on public officials versus the impact on the general public, it's possible that the Commission would have concluded that the narrow scope of Section 84308 at the time indicated less urgency or less severity of the problem, particularly given that the catalyst was a specific instance of pay-to-play politics. Today, however, the legislature has recognized pay-to-play practices as a problem that's long-standing, well-documented, and real, and consequently expanded the reach of Section 84308 to a significant degree. Ultimately, while staff emphasizes that a look-back period extending into 2022 would not constitute impermissible retroactive application of a law, we also recognize that there are reasonable arguments to be made for either application. However, given that the act is to be liberally construed to accomplish its purposes, including disqualifying officials from acting in order that conflicts may be avoided, in addition to the relevant case law and legislative history, the legal division's best interpretation of the legislative intent is that Section 84308's look-back period was intended to extend into 2022. Again, I appreciate all the input from the regulated community as it helps highlight the relevant concerns and considerations, and we would also welcome additional input with respect to the subsequent opinion and regulations after receiving feedback from the Commission today. With that, I'd be happy to answer any questions the Commission may have.
Thank you, Mr. Cornwall. Appreciate your work on this. I have read myself all the retroactivity cases, and I will say it's not the clearest body of law that we have out there. Before I go any further, though, I need to disclose that I did have an ex parte conversation with Senator Glazer, who's the author of Senate Bill 1439, prior to today's meeting. So I need, for purposes of our ex parte contact rules, I want to disclose I did have that contact. If I'm understanding your presentation correctly, Mr. Cornwall, staff's view is that under the case law, your best view is that it would not be retroactive application of the law to apply contributions made this year for purposes of the recusal requirement that goes into effect in January of 2023.
Correct.
That's correct.
Yes.
However, staff's position is that even if that's true, this commission, as a matter of policy, can decide whether to count the contributions made this year for purposes of the recusal requirement going into effect in 2023 or not. Is that true?
That is also correct. There, as I stated, there are reasonable arguments for both modes of interpretation with respect to the legislative intent here.
All right. Well, I will just say for my part, I agree with staff. I'm not sure that it would be a retroactive application of the law here to count the contributions from 2022 for purposes of recusal requirements beginning in 2023. However, I am concerned that this commission, as you acknowledge, when faced with precisely the same question when this law was originally enacted, chose to delay counting contributions until the law was fully in effect. And while I appreciate staff's perspective, I'm not sure I've heard a compelling reason to take a different approach here. And I have some concern that the legislature presumably would be aware of how this commission implemented the law the first time. And I don't think we've given any indication that we would do something different today than we would have done when the law was originally enacted, nor was there any indication in the legislation that the legislature's understanding would be that we would take a different approach than we did in 1983. So based on that, my position is that we ought to issue an opinion advising that the contributions made this year in 2022 do not count for purposes of the recusal requirement going into effect in 2023. But that's my view. I'd like to now open up to my colleagues.
Go ahead. I defer to the Vice Chair.
All right, Commissioner Baker.
Thank you, Commissioner Wilson and Chair Matich. I'll not bury the lead. I have the same reasoning because of that 1983 action. But I want to say thank you for the thoroughness of your memorandum and the presentation today. The additional reasoning that I have leads me to the same conclusion is, in my time on the commission, we've had one other instance where we have this question of, I'm just going to call it retroactivity. And that was with respect to the bill, I want to say AB 571, but I may not be getting this.
Sanders' opinion?
Probably. Local campaign contribution limits. I know the author of the bill was Kevin Mullen. That's what sticks in my mind. And we had that very same analysis. And as I read through your memorandum and listened to your presentation, I kept asking myself, how is what we did in that case distinguishable from what we would do here? Because I felt in both instances, the legislation did not say either way. And in fairness, we're the Law and Policy Committee. We didn't think of asking the question about retroactivity, although I'm sure that's going to go on a checklist for the future. And we were confronted with the same many questions from the regulated community in a short time period. Can you address if and how we concluded in that matter is distinguishable here and leads to the staff recommendation that I'm just going to say retroactivity, that you can be retroactive, although I understand your premise is different.
Yeah. So with the Sanders opinion, I believe that the opinion that the commission ultimately adopted noted some of the concerns with respect to concerns about the First Amendment, but also with respect to retroactivity, but ultimately didn't decide the opinion on that ground. It was based on the language of the text. And in that particular case, which dealt more generally with contributions generally, and not in the context of contributions by someone appearing before the recipient of the contribution, there was a a subdivision of that statute that had a delayed effective date. The bill was passed in 2019 with an effective date going into January 2021. In which case, I believe that the commission inferred from that the legislature included that there for a reason. Whereas here, as I said, the legislature could have included a similar delayed effective date in this instance, but ultimately declined to do that.
And another area that repeatedly, thank you, that popped up in my mind, and the language in your presentation today is a little bit different. In the memo, on what was emphasized, and you see it on page 6, right in the middle, the paragraph that starts in each. In each of the 3 cases, no liability applied to the subject until a future triggering event occurred. Again, this is the paragraph in the middle of the page, second sentence.
Mm-hmm.
And what I zeroed in on is the focus that it's liability. And I think I may agree with you there that maybe no liability attaches, but legal consequences change if we adopt the staff recommendation. And in your presentation today, the cases that you quoted, and they were also quoted in some of the comments letters we have, is that the standard isn't if there's legal liability, it's legal consequences. And from my perspective, I feel that if we look back 12 months prior to the effective date, that changes the legal consequences of those decisions, even if it's not rising to liability and potentially until a future act. So where I'm going with this is I did not read all the cases. I know that your language changed a little bit this morning from the memo, and it could be unintentional, but it might be. And that one of the cases, I believe it was in the letter submitted from Bell McAndrews, a law firm, a Supreme Court case, either McClung or McClure, it uses the language legal consequences. And if legal consequences from the past change, it's retroactive. So can you address that either from the case law or your own step back analysis, the difference between legal liability and legal consequences?
Yeah, so I don't think it was an intentional differentiation there. That is correct that it states a change in legal consequences. From my reading of the various cases, it really comes down to essentially when the last triggering act occurred, and they've talked about it. And again, I continued to research the issue in light of all of the comments we received, and unfortunately, there is no case that specifically deals with retroactivity in the context of contributions or the Political Reform Act.
We could only be so
yes,
lucky.
right. But in the context of of criminal cases, in Grant, for example, that was that was a case I cited earlier, a criminal case. That was a case involving enactment of a criminal statute that dealt with an ongoing course of criminal conduct. And in that case, the criminal conduct, some of it had occurred prior to enactment of, or the effective date of the statute, and other conduct occurred after the effective date. And in that case, the conduct prior to the effective date of the statute would not have constituted a crime until that subsequent conduct occurred after the effective date. And that was the case that essentially emphasized the fact that it's the triggering act where the crime essentially becomes completed that is the relevant date to focus on. And in this case, under these circumstances, the relevant date, no one has committed a crime by accepting a contribution, or in cases where they both accepted a contribution and took part in a proceeding in 2022, there's no liability or consequence as a result of that. It's the subsequent decision to take part in a proceeding that they're otherwise disqualified from, where the consequences come into play.
Thank you. I think I'm still leaning towards a distinction between legal liability and legal consequences, and that I feel like doing this look back will definitely change those legal consequences. I'll keep considering your point there. My final one, if I may, Mr. Chair, is on the cure provision, because that was also raised by the comments. And that, what about the argument that if this was intended in any way or appropriate to look back, the cure provision in many respects doesn't make sense because somebody can't do it. You do address it somewhat in your memo, and I just wanted to give you an opportunity to elaborate or say more about, if we were to look back, doesn't the cure provision sort of stick out like a sore thumb, is not quite complete or fixable? I'm getting that right.
I'm sorry.
Okay.
Maybe
I'm
connection are
confusing.
you
No,
drawing between the cure provision and
So I believe, and please
You
correct
get what I'm
correct
trying
me
to
if
do.
I'm wrong. I believe Commissioner Baker is referring to the instance in which a local elected official both had knowledge and received a contribution exceeding $250 in 2022. And by the time the effective date comes into play on January 1st, more than 30 days has passed. So the cure period in which they're permitted to return that contribution in order to take part in the proceeding is inapplicable in that instance. And I think that is a circumstance that warrants consideration, but I think it's also needs to be weighed against effectively delaying implementation of this law that's designed to protect against the appearance of pay-to-play politics for up to another year. I think it also creates, the alternative creates a circumstance in which an official who receives a $5,000 contribution on December 31st has no problem taking part in a proceeding, whereas the official who receives a $251 contribution on January 1st is prohibited. So I understand that it's not a perfect either way, but
Right.
I do think that there are valid considerations for applying the look back period to 2022.
Thank you for that, and thank you for explaining my question better than I did. That if there's something that I don't want to say it makes a defect, but it makes a situation where the cure provision can't happen, to me that leads to some sense of legislative intent. That if you write a bill that then your full provisions can't work, then maybe it wasn't intended to go back that way. So I might be trying to divine legislative intent. Thank you for the answer to my questions. I do appreciate it.
I have a question about the cure period.
Yes.
The official has to have knowledge of the matter being before them, before that 30-day time period starts ticking, right?
That's correct. So in most instances, well, I shouldn't say most, but in many instances where the official has already received a contribution, they may not already have, they may not also have knowledge of the proceeding because it hasn't come up. They don't have actual knowledge, or it hasn't come before them in terms of an agenda item, and that's something that is included in our regs, which we're also planning on working on our regs going forward, and clarifying some other aspects of 84308.
Yeah, I just think that was important because I do think, I mean, look, this is a new law. It has a lot of detail in it. I know our implementing regulations are likely to be very detailed. I think it's important because I think a lot of people assume that 30 days runs from the time of the contribution, but that's not the case. It's when they have knowledge of the proceeding, which you would not assume on the natural is going to be at the same time of the contribution.
Correct, and
separate acts.
I think that also brings up another point raised in at least one or two of the other comment letters, which was a concern that someone running for office I guess I'm not sure of led to this belief, but a couple of the comments stated that someone running for office but not currently in office wouldn't have the opportunity to cure, but in that instance, because they weren't an official, they would still have the opportunity to cure once they came into office.
Thank you. Commissioner Wilson.
A lot of the questions that I have already been answered. First of all, Ms. Cornwell, thank you for the detailed analysis and opinion. I know that a lot of hours were put into this project. And
Thank you.
a number of issues have been covered. I went back and looked at the legislative history, and SB 1439 was passed with little or no opposition unanimously in both houses.
Yes.
By a 2/3 vote because it amended the Political Reform Act. The author and the legislature had the option of putting an urgency clause into the bill, would not have changed the vote threshold, so that the bill would take effect immediately. The fact that the legislature chose to pass this bill to amend the Political Reform Act, just based on my reading of the analysis, it was not intended to apply retroactively. Now, I understand the detailed and well done analysis on the look back provisions and whether the bill should be applied retroactively, but with close to I don't know the exact number, but close to 480 cities that are throughout, or local governments throughout the state. It's a lot of elected officials that might look at this legislation and say, oh, okay, it applies effective, January of 2023. And to have it apply retroactively when elected officials relied on the law that was in effect in 2022 just doesn't, seem logical to me. It doesn't make sense because the legislature had the opportunity to either put in intent language or have the bill take effect immediately, which I think would give a stronger argument to the retroactive application. So, but thank you.
Thank you.
Commissioner Gomez, anything? Commissioner Wood?
First, a sound check.
Hold on.
So,
Did it work?
Commissioner Wood, can you do me a favor? Can you call into, do you have your phone handy? Can you call into the public comment line and make your comments that way?
Also, if IT has a moment, they can switch her audio.
Can you guys do that quickly?
They just need to make some noise, is
They
what I
are-
understand.
All right, thank you, Commissioner Wood. We're having sound difficulties with you.
Can you hear me? You can't hear me, huh?
Welcome to AT&T's Health Service. Please enter your access code, followed by the pound sign.
Session. Oh, okay.
So I feel like I should say something really amazing now because you all had to wait for so long. But I don't know that I have anything that amazing to say. I wanted to thank Mr. Cornwall for defending the staff position so well and really making a big effort. But I also agree with everybody who's spoken so far that it's probably best if we just avoid this situation by starting to count things from contributions starting at the beginning of the year. But I also wanted to just raise something, and this is why I didn't give up on this comment, that I think we may, and I'll bring this up again at the end, but I think that we may want to be talking to legislators about something they've missed here, which, or maybe they missed it on purpose, I don't know, but, you know, pay to play is just about when an officer's, I guess, committee, right, receives a contribution, but there's a lot of it that happens through independent expenditures as well, best I can tell. You know, there are local candidates who don't do a lot of their own fundraising and get a lot of support from PACs, super PACs and things like that. And so it seems to me that that this is only part of the pay to play story. And so my question for Mr. Cornwall is, am I right that the commission doesn't plan to interpret this to include outside money at all? And then I guess my urge for a future agenda item is just to discuss whether we wanted to ask the legislature to go ahead and be thorough in this pay to play prohibition.
My understanding of the legislation and the legislative history is that you're correct that it doesn't include independent expenditures.
Sorry, I just want to be really clear because I was fighting with audio. That you said it does not include independent expenditures, right?
Correct.
All right. Thank you, Commissioner Wood. Thank you. Any further commissioner comments or questions for Mr. Cornwall? All right. Then I will make a motion that we, without prejudice to staff's incredible work, particularly on the retroactivity issue, I would move that we adopt an opinion that advises that contributions made this year do not count for purposes of the recusal requirements in Senate Bill 1439. Do I have a second?
Second.
You know, we're going to give Commissioner
I was
Wood a
going to
second.
second.
Yes.
And also, I want you to know that I have arranged my teaching where I can be this person in the spring, and I see my empty seat waiting for me. So I'm sorry about these audio problems, but we will get sorted out.
No problem. Looking forward to having you in person, Commissioner Wood. Is there any public comment on this item?
Hi, good morning. I am Corey Manning. I'm the General Counsel for the League of California Cities, the party that requested this opinion. We agree with all of the things that have been said today about why the opinion should be issued to not apply to contributions made prior to January 1st, 2023. So I won't belabor that anymore. I just wanted to stand up here and say and reiterate our commitment through the FPPC committee of our city attorney's department to continue to work with the commission and commission staff on the implementation of this law, even after January 1st, 2023. We're concerned about some of the practical implications of the law that weren't taken into consideration when the legislation was passed. And so we just want to reiterate that we would like to be a partner with the commission and commission staff to address some of those through implementing regulations. Thank you.
Thank you. Any additional public comment?
Jay Carson, Nielsen Muxmer, my firm submitted. Hi there, Jay Carson, Nielsen Merksmer. My firm submitted one of the comment letters. We agree with the commission's decision today to not apply these provisions retroactively. I got it because I have a question about timing. I understand the commission is not holding a December meeting and the next meeting would be in January. So what would be the timing of the adoption of the commission opinion? What I'd like to avoid is that we have 19 days in January where the law is still in flux.
Mr. Bainbridge?
We'll bring an opinion back, assuming there's enough votes, but I can count noses, in January for adoption by the commission. I think to concerns about what law applies, I think it's pretty clear, or at least after the vote, it'll be pretty clear the way the commission will be interpreting this provision. Of course, it's an opinion, so it's only specific to the requester, which is Mr. Kendrickson. But I think today we've seen where the commission feels this will go, and I anticipate after the opinion has been adopted, our regs will also reflect the position of the commission on this.
Thank you. We would just ask that the opinion and the regs reflect that they are effective as of January 1, so that there's no 19 days in January where there's any issues of the law not applying.
Well, the opinion can't do that because it's the opinion of the commission. It's not making the law applicable one way or the other. And the regulations will be applicable once they're adopted. I think the value of the opinion to the regulated community at this point is they know on this issue what opinion the commission would give the specific requester in this instance. So how the law will be interpreted, it's not changing the law in any way.
Fair enough. Is there a way for the commission to issue a statement of policy today to again clarify their position in 2022 so that there's not any issue again for 19 days in 2023?
Yeah, I understand why that would be helpful. I think the issue the commission would have with that is we start to get into an area where it's rulemaking, which we have to follow the rulemaking process to do that. So there's really nothing the commission could do today other than state what they would like the opinion to read in January. I think is kind of the best you're going to get from them today.
Mr. Bainbridge, is it theoretically possible that the commission could call a special meeting in December at some point and appear telephonically to vote on the draft opinion as a theoretical matter?
Theoretically, yeah, you just need to have 10 days notice of a commission meeting. So we could do that, and telephonic meetings are still possible. I would note that next week is Thanksgiving and staff has to put work in to do these sort of things. I think what they're requesting is unnecessary because what the opinion means is it's the commission's interpretation of the law. And I think there will be a clear statement of how the commission is interpreting this law in January. I understand it'd be better if it was on the books January 1, but that doesn't change what the law is. This is simply the commission's interpretation of what the statute says. So what I'm saying is, yes, we could do it. I think it's unnecessary, and I think it would be a burden on Mr. Cornwell, frankly.
Right.
But we can do it if that is the commission's will.
Hang on. Because I understand your concern about a quick turnaround if we were to hold the telephonic meeting on the same date that we previously had a meeting scheduled in December.
14th, actually.
Wednesday
the 14th.
Well, what I'm about to recommend is if we pushed that to later in the month, that gives staff more time to do that. And I would expect it to be a very relatively quick telephonic meeting at that point in December. So if we scheduled it for the 22nd of December by telephone, would that give Mr. Cornwell more time?
Yeah, I think adding additional time, I think that's a good point of not trying to do it the third Thursday, but giving us a little more time would definitely be helpful.
All right. Do other commissioners have a view on that? Can everyone make themselves available for a phone call on the 22nd to consider an opinion?
I will do that.
Yes.
I'm traveling that day.
Okay.
I'll do it whatever time zone I happen to be in. If it's telephonic.
All right. I think it appears that we would be able to muster a quorum on that date. And so let's schedule, to address the regulated community's concerns, let's schedule a telephonic commission meeting, special meeting on the 22nd for the sole purpose of considering the opinion and Ray Kendrick's matter.
Thank you very much.
Thank you. Any other public comment? Hearing and seeing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Gomez? Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Thank you again, Mr. Cornwall, and sorry to jam you up on your opinion. as
No
well,
problem.
but
Thank you.
Thank you. Yeah, okay. All right, let's go ahead and move to item 11, legislative development with Senior FPPC Legislative Counsel, Ms. Nakano.
Good morning, Mr. Chair and Commissioners. I think it's still morning, so a couple minutes there. Today I'm presenting a number of legislative ideas for discussion and feedback. And after discussion, the Commission may vote to direct staff to pursue any or all of these ideas as potential sponsored legislation. I'll start at the top of the list located in today's legislative memo with the ideas listed under the transparency heading. The first idea is a reintroduction of SB 921 from this past year. This would create a centralized public record of campaign ads distributed on online platforms. The general purpose of the bill is to create more transparency about the campaign ads distributed online by, for example, allowing the public to view the campaign ads released by a particular committee across multiple platforms, and to view all online ads associated with a particular campaign or election. The second idea relates to paid influencer posts about a candidate or measure. This issue came up during a previous presentation to the Commission on new regulations relating to the Act's disclaimer requirements, as presented by Commission Counsel Torrin Lewis. Currently, the disclaimer requirements do not cover situations where a candidate or committee pays a third-party social media influencer to post content about the candidate or measure. The Act covers content posted directly by the candidate or committee on social media, but it does not extend to content posted on social media by a third party paid by the committee or candidate. This means that to the public, these kinds of online social media posts appear to be coming directly from the third party person and could appear to be exclusively that person's own personal speech, as opposed to the reality, which is that they have been paid to deliver a campaign message. So this bill would require a disclaimer for the purpose of informing the public that the influencer was paid by a candidate or committee to post the content and deliver that message. The third idea relates to creating transparency about who and what interests are attempting to influence the decisions of local redistricting commissions by expanding the Act's definition of lobbying to include lobbying of these commissions. And I'll pause here for any discussion from the Commission before I move on to the other ideas.
Any questions, Ms. Nakano, on the first three ideas? Hearing and seeing none, please continue.
Thank you. Moving on to ideas relating to the online campaign finance filing system and campaign finance reporting. Idea number 4 relates to the filing of reports and statements with the Secretary of State's office through the future version of their electronic campaign filing system, known as the CalAccess Replacement System, or CARS. This potential legislation would streamline the filing process by allowing another individual designated by the candidate to file or transmit statements on behalf of the candidate. As the memo notes, the candidate would retain ultimate responsibility and liability for their own statements. Staff is continuing discussions with the Secretary of State's office relating to what will be both helpful and possible under the new electronic filing system in this area, and I will keep the Commission updated as that advances. Number 5 also relates to campaign finance reporting. As we are able to look forward to an updated electronic filing system that will be adaptable to changes in reporting requirements, this presents a new opportunity to reevaluate the campaign finance filing schedule. Our current filing schedule was built over time in a more piecemeal fashion as the result of many different pieces of legislation. And sometimes policy decisions were based on the limitations of the existing electronic filing system. So staff thinks that we are approaching a period where it will be both possible and greatly beneficial to redesign our filing schedule in a holistic way based on best practices and taking advantage of the new technology that will be available. One potential new model would be to move to a monthly filing system with activity-based reporting only during some period before the election, such as 30 or 60 days. We imagine that this will be a multi-year project as staff understands the need for robust input and feedback from the regulated community and stakeholders. And to be clear, these changes would not be made until sometime after the new CalAccess replacement system is certified. And I'll pause here. Any questions? Thank you. The sixth idea would update privacy protections under the Act to provide for the redaction of bank account numbers on statements of organization provided to the public for purposes of protecting financial security of committees and candidates. The Commission's legal division is also assessing whether there are any other areas in the Act where privacy protections could be appropriately updated, so other proposed changes may be forthcoming. Number 7 would require contributors to certify that their contributions are in compliance with state law. This certification would educate contributors about relevant requirements and would incentivize contributors to make sure that the information they provide is correct. For example, the certification would state that the contributor is not using another person's name, they're not using a false name, and the contributor will not be reimbursed for their contribution. This idea originated from a similar requirement in Los Angeles. And from my conversations with their ethics folks so far, they report positive experiences with this requirement. In the Law and Policy Committee last week, there was a question about the form of the certification. In Los Angeles, it's a one-page document that includes information about the contributor and the contribution, as well as the statements that the contributor is certifying as true. This certification is submitted to the committee along with the contribution, the committee that's receiving the contribution, and is retained in their records.
Thank you. And thank you for the question about form. It's very helpful. Have you explored if there's a minimum threshold or if this will be for every contribution, $5 or $5,000, if there's going to be a monetary threshold to begin this requirement?
In Los Angeles, I believe it applies to all contributions. For our purposes, we could explore limitations.
I don't have feedback on that yet, but I think we just want to potentially have that on the table to see how, if there's going to be a minimum threshold where that triggers. We have those in lots of areas, and we may want to consider that. Thank you.
Thank you. Okay, moving on to idea number 8. This would create a long-arm statute to add commission authority to exercise personal jurisdiction over out-of-state persons in order to give the commission additional tools to obtain relevant documents and testimony of persons located outside of the state. The 9th idea relates to Section 1090, which generally prohibits an officer, employee, or agency from participating in the making of a government contract if that person or agency has a financial interest in that contract. The Enforcement Division released a memo in January of this year at the Commission's request, which concluded that only the parties to the contract have standing to bring an action to declare the contract void that is in violation of 1090. This idea would add authority for the Commission to initiate the judicial process of seeking declaratory relief to void the contract that the Commission finds in violation of Section 1090. And to be clear, this idea would not give the Commission authority to itself void the contract, but would give them standing to seek that declaratory relief through a longer process in court.
I have a question on that one, Ms. Nakano. So DAs who have the prosecutorial authority over 1090 don't have the ability to go to court and set aside the contract?
According to the most recent court decision, only the parties to the contract have that standing.
Do we have any idea how often this is a problem where a 1090 violation is found and nobody moves to void the contract?
For the Commission's purposes, obviously we've only had one case. In terms of the district attorneys, I don't have figures on that, but that's something that we can do some further research into.
All right.
Any other further questions on that one? Thank you. And number 10 relates to the prohibition in the Act against certain mass mailings sent at the public expense that feature a candidate that will appear on the ballot. The Act prohibits these mailings during the 60 days before an election. Existing law applies only to tangible mailings, and this idea would extend the prohibition additionally to emails sent at the public expense. Number 11 would allow the Commission's Statement of Economic Interests unit to waive the late filing fee if the filer was unable to file due to being ill or hospitalized. Currently, the SEI unit has some discretion to waive the fee, but that discretion ends after 30 days after the statement is due. So this idea seeks to provide a reasonable leniency where there is good reason. Number 12 would require electronic filing of statements of economic interest that are filed with the Commission for the purpose of modernizing filing requirements under the Act. We saw some mandatory electronic filing in a bill from this year, AB 975, which may be reintroduced this year, or this coming year. Last, number 13 would include various minor changes to the Act. The first relates to what counts toward the voluntary expenditure ceiling. And I'll start with a little background. This issue was discussed in the August 2022 memo by Senior Commission Counsel Erica Boyd. The memo included relevant legislative history, and in short, in 2017, the legislature passed a bill that reorganized various provisions that were located within the definition of contribution by moving other terms and substantive reporting requirements into their own sections. According to the author's statement in the committee analysis, the purpose of the bill was to clarify and streamline the definition of contribution, and they stated that there was no intent to create new requirements or remove existing ones. Despite this intent, it appears there was an inadvertent substantive change. Prior to the 2017 bill, the phrase campaign expenditures was defined to include 7 of the 8 activities listed under the definition of election-related activities. The activity that was specifically excluded was preparing campaign finance disclosure statements. The 2017 bill did not include that exclusion, thus broadening the definition of campaign expenditures for purposes of determining what counts toward the voluntary expenditure limit. Again, the legislative history here suggests that this was an inadvertent error, likely simply a drafting error when things were being moved around. So we would seek to correct this error in this bill. The second idea in this package relates to limits on personal loans. The Supreme Court this year found limits on the repayment of candidate loans unconstitutional. The PRA currently imposes a $100,000 limit on loans from the candidate to the candidates committee. This change would strike that limit consistent with the recent decision. Third, in this bill, this idea would add further authority for a filing officer to waive the late reporting fee if the person successfully completes the PREP program, which is the Commission's political reform education program relating to that late filing. As I mentioned previously, because of the 30-day limit on discretion to waive the late filing fee, participants of PREP would be liable for the fee even if they successfully completed the program. StaffLink's waiver here is appropriate and consistent with the goal of PREP to provide an alternative to any penalties. As a last note, additional changes, cleanup changes may be added to this bill as identified by staff, including things like incorrect citations within the Act. And I'm happy to take any questions or feedback.
Thank you, Ms. Nakano. I think this is a good list, and I appreciate your work helping us formulate it. And it is a slate of proposed legislation that we recently approved at the Law and Policy meeting for consideration and recommended approval by our colleagues here today. Since then, I have had one item that I've had some second thoughts about, and it's item 10, the mass mailings. And it is driven by the fact that I would like us to explore whether we have regulatory options there first before we move to a legislative proposal. And so my only change to this list I'd ask my colleagues to consider is moving mass mailings to a future regulatory project for Mr. Bainbridge and taking it off the legislation list for this year. That's my only comment on the list, though. Yep.
With all due respect to the members of the Law and Policy Committee, what is the rationale for number 3, lobbying of local redistricting commissions? I mean, I understand what's stated in the memo, but is there a real need for that type of oversight?
I think generally the policy argument is that there's a public interest in shedding light on who is trying to influence these kind of proceedings. They have a huge impact on the balance of power in the state. So it's just a matter of transparency with relating to who is attempting to influence those proceedings.
But, without knowing all the details of my colleagues' rationale, it would seem that local government or some kind of regulation or oversight at the local level, or even by the actual redistricting commission, would be an option. But I'll continue to keep an open mind.
Thank you.
Thank you.
Commissioner Baker?
Thank you. I concur on item number 10, looking at regulatory options. Just wanted to chime in as a Law and Policy Committee member after we went over that, and I appreciate you raising it. We want to be efficient with your and respectful of your time in the legislatures if it's something that we already have legislative authority to do. Thank you.
Any other questions or comments for Ms. Nakano on the legislative slate, proposed legislative slate? All right, is there any public comment on item 11? Hearing and seeing none, I would move commission approval of the recommended slate of 2023 legislation ideas with the following change: that we remove item 10, mass mailings, from the list, and instead request Mr. Bainbridge to research that issue and report back at a future meeting.
Second.
Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Gomez? Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right. Thank you, Ms. Nakano.
Thank you.
All right, and that is a perfect segue into our next item, which are the regulation projects for 2023. Mr. Bainbridge.
Yeah, good afternoon. Typically, we've brought the proposed reg calendar to the commission in December or January for that year with a schedule all laid out and a detailed description. This year, at the suggestion of the chair, I'm bringing the list that I've collected to this point of regulations we think staff feels like we should tackle this year. I've identified the source of where we came up with these, but I keep a running list all year long. And these are the ones I have on the list for now. So I'm bringing it to the commission today to get some input. If there's other issues they'd like to see added, we can talk about that. And then I plan to bring back the formal memo with the schedule of the actual months when we plan to present each package in January. So just to discuss what we have here, the first 3 are based on legislation. So because of legislation that passed this year, we need to make changes to our regulations. The Levine Act is the 84308 issue that we spent quite a bit of time talking about already today. So we've identified that as requiring some regulatory updates. Return of over limit contributions is that legislation largely codified our existing regulation, but also went a little further. So we'll need to revise our existing regulation to reflect the changes made by statute. And then same with the advertising disclosure rules. Because the rules were changed, we're going to have to adjust our regs to reflect the changes. Those last 2 I don't expect to be real significant changes. I think it's just making sure cross-references match and parts that have been codified in statute can be removed from the reg, those sort of changes. I think, as we've seen today, the Levine Act opens up a lot of potential issues. So that's going to take a lot of thought and working with the people that will be subject to this law and making sure the regulations further the intent of the legislation while still being workable for the people that have to follow it. So those 3 things I would identify as ones we will be prioritizing so that we can get the regulations in place since the laws go into effect on January 1st. And then after that, we've got a few other issues that we've identified. One is collection of enforcement penalties. So this is a regulation detailing how enforcement penalties, once the commission has issued a decision on an enforcement case, we then have to try to collect those penalties. We don't currently have a regulation in place that sort of lays out the process that the agency uses to do that. So we see a need for that, and then also potentially allowing for lessening penalties or waiving penalties in very specific circumstances, such as the respondent is no longer alive, or it's very old debt and the cost of trying to collect it outweighs whatever the debt is. Those sort of limited circumstances where it would make sense to write down the debt from what the original commission penalty that was levied. Currently, the staff has no ability to lower a penalty amount because it's a commission order saying what the penalty should be. So this would give likely the executive director, but someone at the agency, some authority in certain circumstances to lessen debts that are owed or even waive them. And we can talk about that more as it gets closer and what the commission, sort of what they want that to be and how strict and that sort of thing. But that's the general idea on that one. I'm on to the fifth one. This is a couple of issues we identified through the course of the election. The statute has accounts for two situations, and there's a third situation. We think these are pretty minor and pretty logical interpretations of the statute. We just want to make it specific. They both relate to what to do with campaign funds that are left over after an election. One deals with the issue where a candidate withdraws before the primary. So currently the statute is specific what you can do with remaining funds for the general election if someone loses the primary, but it doesn't say what you can do if you withdraw before the primary if you've already raised funds for the general election. So that, just to give you an idea of what this issue is that we're looking at. And then the other one has to do with situations where an election, someone wins at the primary stage, so there's no need for a general election. There's some rules that say what you do after the election is complete. And the question is, well, do we have to wait until the general that doesn't happen is done to say it's complete, or can you say the election is done after the primary? So those are the two issues we're looking at with that. We've given advice on them, so we'll largely just be codifying the advice we've already given. And then the last one is clarifying that lobbying the California Citizens Redistricting Commission, so the state redistricting commission, it does qualify as lobbying under the act, so it would trigger the lobbying reporting requirements if someone was attempting to influence the officials that are on the Citizens Redistricting Commission. The legislative proposal has to do with local redistricting commissions. This would just apply to the state. And I don't think I think the law is pretty clear that this would be a quasi-legislative decision that they make every 10 years when they redistrict at the state level. I just understand, I believe it was from a media report, and the chair had mentioned this, that there might be some question about whether it does qualify as lobbying. So we figured we got 10 more years, but we might as well do this now before we forget about it. So that'll be towards the end of the calendar. And then I would just note there's 6 items on here right now, which may look a little light, but I always like to leave some room towards the end of the year for new things that come up as the year goes on. With that, I'll take any questions or suggestions or comments. You could also email me if you think of something between now and January, because I will be coming back with a schedule in January that we'll be proposing.
All right. Thank you, Mr. Bainbridge. A question for you on the Levine Act implementing regulations. Do you plan on doing an interested persons meeting around those? It strikes me that we have a lot of stakeholders with a lot of interest in this, and so it's truly just a question if you've thought about that, if that's something that you intend to do.
I haven't thought about it. We usually wait and see. Obviously, the pre-notice is an opportunity for the public to come weigh in as well. They also are welcome to send me information in advance of that. I really encourage them, the earlier the better. I've already talked to the League of Cities attorney who was here today about that. So yeah, clearly there's some public interest in this issue. So we will take it from now until whenever. And if I would say maybe after pre-notice, if we feel like there's a need to get some additional input from the people who are subject to the law, we could hold an interested persons meeting.
Okay, all right, I appreciate that. And then the other comment is just, I think I've already added to your list, mass mailings research. So
Yeah, I'll bring that back in January along with the proposed calendar, and I'll leave a spot where we can write it in if we decide to.
All right, thank you. Any other questions or comments from Mr. Bainbridge? No. No? All right, thank you, Mr. Bainbridge, appreciate it. All right, we'll now move to our next item, item 13. This is the fiscal year 2021-22 year-end expenditure report. With us is our Chief of Administration, Ms. Hahn. Is it still up? Good afternoon.
Good afternoon, Chair and Commissioner. Larissa Hahn, Chief of Administration, here to present item number 13, fiscal year 2021 and 22 year-end report. So this is basically covered period of July 1st, 2021 through June 30th of 2022. And the year-end report would demonstrate that we were totally allocated 15.36 million, and we spent close to 15 million, a little over, and we have a balance of $339,000 by the end of year of June 30th, 2022. And I would like to point out that the total allocations for staff, which is the first column of salary and wages, was at 13.4 million, but at the end of the year, the total expenditure was only 12.5 due to there's some vacancy savings and benefit saving that it did attrition by the end of the year. So they were saving approximately 900,000. And some of you might question why I have negative number within the balance, year-end balance. And the negative number is due to that we anticipated that there was an overage from the salary and wages. So we actually toward year-end, and we anticipated that. So we went out and did some purchases that we think we could afford, such as new laptop for staff and commissioner, because we're at the end of the year, and we have like most of our laptop are old or computer, they're old, so we need to replace them. And then that would have been a good time to purchase some of those that we knew we have saving that we could afford to push forward. Okay, and then those purchases actually came in under the line of general expenses under capital assets purchase and non-capital assets purchase of 81,000 and 192,000. Because for the past couple of years, staff have been teleworking, and there was requests of certain sit and stand desks for herbal purposes, and so that's one opportunity for us to purchase some of those equipment and furniture to our staff to provide what they need being at home. And then moving on, the next negative number on the column will be the consulting and professional service. Just to let you know, we didn't really under budgeted. We were right on target on budget, but because we have money that we anticipate was going to save through the salary and wages and benefits, so we went ahead and did another contract. So the consulting professional service included two types of contracts we normally do. One is what we call the interagency agreement, where we have contract with other state agencies that we agreed on to acquire them to help us with certain service that we do, such as like CalHR, DGS, Department of General Service. So one of the contract we did at the end of last fiscal year was a contract we hire Department of General Service Real Estate to consult with us to provide us feedbacks and planning, because our contract here on the lease, it's a 4-year soft and 4-year hard terms. So we started the contract back in 2017. So we already exercised the 4-year hard term, and we're on the soft term at this point. And our contract would end sometime in the middle of 2025. So with that anticipations, we would have to hire Department of General Service to provide us assistance with either remaining here to renegotiate a new contract with the landlord or moving elsewhere to find us a space. So those are money that we contracted aside for Department of General Service to help us to plan out our next lease, which, to help us plan the next lease, and then for the real estate agent to help us renegotiate a new contract, either being here or somewhere else.
How much of the $612,000 figure is attributable to that services contract with DGS you just described?
We actually spent $175,000 through that contract. And then the second contract I was going to speak to, it would be a contract we did with our vendor. So most of you who file Form 700 know that we have an online filing system. So we procured that system back at 2015. And the system, it's an online system that we only own the data but not the software. So we have to purchase the software through Granicus, which is a company that provides that service to us. And the contract itself on an annual basis, it's around $350,000. And our contract with them actually ended on March of 2022. And then, but we were allowed to do an extension for 1 year without going out on the street for another bidding process. So we took that liberty of doing that through the approval of Department of General Service. So because of that, so I encumbered the money that we would have for that 1 year period, which would start from April 1st of 2022 through June of 2023. Into anticipation that $350,000 on the contract we pre-encumbered for the year.
All right. So the consulting professional services row here, the allocation for 21-22 didn't include anticipated expenditures related to the contract that you just mentioned we knew was going to be expiring?
Yes and no. Okay, I'm going to explain that a little bit. Because the contract actually ended in March, so the only expenditure we thought we would do for that 1 year would be April, May, and June. Because we encumbered the contract for a 12-month base, and that's why the contract is $350,000. So we actually pre-encumbered the money that was spent on July, August, September for this current fiscal year in the previous year.
You prepaid it because we had money left over from other services.
We
sources.
We encumbered it. We haven't paid yet. So, but it's in the bank. Yes.
Right. Do you have anything else?
And then the next column down, the next row down. Sorry, it's the information technology. It is overexpended by $47,000. It's because at year end, we knew that we have purchased that we want to do, such as upgrading our Adobe license to more a professional where we could make videos and things of that sort. So we actually took the liberty because we have additional savings. So we decided to upgrade our license for some of those IT related purchase.
I have a question.
Commissioner Wilson?
And this is more of a technical question. Do all, and I don't want to misinterpret what you said, do all of the FPPC employees have access to Adobe Pro, or just some have access to Adobe Pro?
So we have different level of Adobe license. Only some have Adobe Pro and some have just basic Adobe, depending on what their job needs. So we assign them type of license based on what their job require them to have access to.
Okay. I mean, I have Adobe Pro on a personal basis, but then could you explain why Adobe Pro can be beneficial?
Adobe Pro actually, it's beneficial to some staff because they do a lot of editing of PDF documents. And then so that's one of the plus of having Adobe Pro, because the basic Adobe will not allow you to go into PDF to make any edits or any changes that you might do on a PDF version.
Thank you. That's my understanding as well, but you know it better than I do. Thank you.
I think you're pretty good at it, Ms. Commissioner Wilson.
All right. Anything further, Ms. Hahn?
Not for this, unless you guys have any question for me and I'm ready. Hopefully I can answer some of your questions.
Thanks. Other commissioners have Commissioner Baker?
Thank you. The chair inquired, one of my questions was to break down that 612,000 a little bit more. Whenever I see things in parentheses on the budget, you're right, sort of like, gee, it looks like a minus, I better find out what that is. But I want to go back a little bit. You know, do you do what I would call zero-based budgeting, where you start from scratch and here's what we need for this year? Or do you carry over numbers from prior years to begin to build out the future? And the reason I ask that is, I'm looking at facilities operation, $878,000. Actual is $651,000. And that prompted a question, not just about, can you explain that more, but also the bigger question is, if you start with zero base, like what am I going to need in the coming year versus I'm starting with numbers from the past and carrying them over?
To answer your question, there's actually twofold. So we cannot carry balance forward. That's a state rule. So if you have money left over from the current year, you're not allowed to spend them the following year. You have to spend them within this current year. Okay. And then so when we do budget, it's based on how much we are allocated from Department of Finance.
Okay. So it sounds like you might be carrying a number over from a prior year as opposed to starting from zero and saying, here's what our expenses would be.
Okay, I got you. So you're saying that the prior year expenditure experience in order to project forward of the following year.
Yes, like basically how you start the budget. I'm probably being way too rudimentary because I'm thinking of my own house or otherwise, but if we start with, okay, I had, you look at actual, this is what our expenses were this year. Here's what I know the expenses are going to be, as opposed to I budgeted for this last year and I'm going to take the budgeted number over. I'm a zero-based budget person, starting from scratch. What are my expenses going to be? And I'm just curious what we do.
Okay, so to answer your question is yes, we do a past year of carrying forward what our past year expenditure experience have been to apply that forward for the following year. So let's use what you just said, the facility operation of the 878,000. So that the reason of that being high and then our expenditure is only 651 and there's a balance of 227 because of the prior year, because the first 4 year of our lease here included we amortized the tenant improvement that we had to pay for, which after the 4th year, we no longer have to pay for that. We only have to pay for base rent going forward.
Okay.
So then you can see that number being high because our experience from the prior year was a lot higher than those actual of this during 21 and 22 because our 4th year has ended sometime in the middle of 2021.
Okay. That explains the 878 to 651 and why the actual is different. So for next year's, which I guess is another budget item, we shouldn't be starting with 878.
Correct.
It shouldn't be carried over.
You will see that on the next item.
Actual expenses are. It's a little bit like zero-based budgeting in the sense that you're going by actual figures, but so that I think that helps me there.
Okay.
Another question I have is about the training. The allocation was for 25,000. Actual is 3,000, so there's a balance. Can you say a little bit? Now, this isn't, because we do training for the public. Is this training for our own team? And if it is, can you say more about? That's a pretty big discrepancy.
Got it.
What changed that the actual is so much lower than what was allocated?
So it's only portion of the training that we spend on our internal staff training. The reason I say it's only a portion of it is because if we take training through CalHR, which they offer a lot of training, some of our staff could take on the courses, those expenditure goes into the line of consulting professional service because they're interagency agreement with CalHR. And they're direct bill, so it's harder for us to track those because they just take it out from our account. Now, the actual training line here is when we go outside training of CalHR. last several years, we have hired this consulting firm, which is called Unleashing Leader, that come on to our site, provide training for our leader, because we're required by Cal HR rules affected 2019, where each manager and supervisor and career executive appointment are required to have 20 hours of biannual training. So I think we started that contract back in 2017 with this company. And because it's a biannual base, sometimes we try to do the training the first year of the biannual base. So therefore, in 2021 and the fiscal year 2021 and 2022, we didn't spend as much as we thought we would, because the prior year we spent all we needed to meet the requirement back in 2019 and 2020.
Can I ask a
Please.
clarifying question?
Yeah,
So,
sure.
taking a step back, for the benefit of the commission, we talk frequently about how we want to do more trainings to stakeholders. That's one type of training.
Mhm.
We also talk about how we want to support our staff and employees by providing trainings.
Yes.
And so what I think you're saying, though, is when we look at the budget documents that you've prepared, there's a training item here, and you've explained why we budgeted 25,000, but we've only spent 3,000. But part of your explanation, I think, is that we did provide more training than what's reflected here. It's categorized under a different row. Is that right?
Yes.
If that's right, then we don't know truly, sitting up here today, how much we actually spent on training. Right?
Yes, because there's two, like I said, there's two categories the training actually hit, because the one of the category, it's in the professional service, because we went through Cal HR. And only if we go outside of Cal HR would we be able to tell how much we spent on training, because those are outside of Cal HR training that we pay for.
So for my benefit, I understand what you're saying. You're doing trainings, but you're drawing from two separate sources because you have to depend on who's providing the trainings.
Correct.
Right? I think for purposes of the commission, it would be helpful if we then could see some kind of a subcategory of consulting and professional services, or categories maybe, so that we can get a truer sense of how much we're spending to train our staff in particular, and then maybe you could subdivide it how much we're spending doing trainings outside for outside stakeholders, so that we have a more accurate, granular perspective on that. Because when I look at this, if I just took it at face value, I would take away that we only spent 3,000 all year on training, but that's actually really understated, right? And that's an important thing for the commission, I think, to see. I mean, at least for my own part, I think that's right.
Thank you. Yes, that was the number that popped out at me, is both because I know we're doing a lot of outside training, so I had to ask first if this is internal, and then it may look like, we're not availing ourselves for whatever reason of training of staff, when it sounds like we are in different ways. So that's why that number popped out at me. I think that's what I've got for this document. Thank you.
Any other questions for Ms. Hahn on the year end from the last fiscal year? All right. Any public comment on item 13 before we move on to item 14? Hearing and seeing none. We'll now proceed to item 14. This is the 2022-23 fiscal year budget summary. Ms. Hahn.
Okay, I'm just going to go into it. Since I wanted to address Commissioner Baker's question about the facility operation, as you can see, I adjusted the number because of past experience. Now we're only allocating $687,000 into rent and facility.
Yes, in fact, I've got that circled on my page. I mean, it's a little different than 651. That was the actual. So there's a $36,000 difference. Maybe that's for some reason or other. I don't need to get that micromanagey, but I do see that the number's significantly different than the budget before.
Yeah, because the rule of thumb when we budget, it's plus and minus 5%. So I always do the plus and 5%, minus 5% onto the budget.
Thank you.
And then I think that's the only thing I want to point out. And then we did get a little bit less of allocation of $15 million compared to prior year, but that number will get readjusted once May revision come through, because usually May revisions, they do a lot of the staff and salary readjustment occur during May revisions.
I have another question for you. I actually meant to ask you the last time. There's a category towards the top says reimbursement. And year to date, we're at 55,000. When I look at item 13, year end, last fiscal year, it was much higher. What is the reimbursement?
So the reimbursement include a couple of things for us. The first thing is the contract we do with local authorities for us to provide the audit or the enforcement portion of the contract. And then so as of today, we only receive 55,000 of the contract that we have with them. And then last year, because it's timing really, it's like if their contract is not due to, let's say, December, we'll see the money at the third quarter because it's actual. So that number will get adjusted as we receive reimbursement from them.
Okay, so I actually have a follow-up question then, because I see the year-end report at the top where it says budget, general fund. That's a number we know at the beginning of the year, right? Beginning of the fiscal year. We know how much we're going to receive.
Yes.
Do we have an estimate of how much we're going to receive in total this year for reimbursement?
So we have currently 2 contracts, and then so the contract will come into play. The base value of the contract are $55,000 each. And then, but there is within the contract, there's language that if we go over a certain amount of hours, then we have authority to bill them more up to a certain value. And then that's why you're seeing the difference between the prior year-end number for reimbursements versus the current year of what we received so far, the 55,000.
So that's what I want to stop you on, because you said that what we received so far in this fiscal year is 55,000, but it's identified as a line item under budget, which is what I would have expected to be the budget for the year, just like the general fund number is the budget for the year. If you want to track how much we've gotten against that budgeted reimbursement, I would have expected that to show up in the actuals. But is that not how I should be reading this?
Not for the reimbursement line, because the reimbursement is not actually, because I can't anticipate how much we're spending, like our staff is spending time to do the audit. If they're billing them more, then we will get it more at the end, but we can't anticipate how much work we're going to do. But the floor is 55. Does that make sense? We're billing them 55 as a floor.
So we only have one contract?
The other contract, the money won't come in until possibly after this fiscal year. It happens like sometime in June. It's kind of tricky of the money where it comes in.
So at this point, is it your position is that for this fiscal year that we are currently in, the reimbursement category at the end of the year would be 55,000 plus whatever overage, if any, there is on that one contract, and not more?
Of the 2 contract, not one.
Because you don't know whether we're going to get paid on the second contract?
Correct.
Okay. Okay, I'm just trying to understand.
Because their contract is a little different. The difference between our budgeting and the contract budgeting, because the contract is by calendar year, and our budget is by state fiscal year. So the timing, there's like a 6 months lag or in advance, depending on where the contract began lies, the effective date of that contract.
Okay.
Thank you. I'm feverishly taking notes on some of these. I think moving forward, and again, I would defer to the chair and other commissioners. Some of the description that you outlined, I think in future reports, it might be helpful to have some kind of staff memo or an outline that kind of covered some of these issues that you explained. That way, when we look at the numbers, They don't just jump out because there's a context. So the format that would be in or how that would be presented, I would leave for you and the chair and the executive director to work out. But I think it would be helpful if there was some kind of narrative on these various budget items. That way, if we're looking back at these budget reports 4 or 5 months down the road, we can say, oh, okay, this is why this number is significantly different than another number.
Yeah, I agree with that. I think a memo that, it'd be very helpful to actually have a written memo for the commission that articulates your methodology. And then highlights, particular discrepancies and an explanation in writing ahead of time so that we can digest it and have a better understanding of our budget.
Okay. I agree. It's like having the footnotes in a financial statement that tells so much of what's going on. And I would benefit from that again because I'm rudimentary otherwise. Thank you.
Excuse me. I don't know how rudimentary you are talking about zero-based budgets in a household, so I think that kind of made me nervous.
All right. Any other questions for Ms. Hahn on the quarterly expenditure report, first quarter of this fiscal year? Seeing none. Thank you, Ms. Hahn. All right, that takes us to item 15, our executive staff reports. And we will begin with our enforcement division report. Chief Brereton.
Good afternoon, Chair and Commissioners. So my report is as submitted, unless you have questions, but I do have an oral update I'd like to give you. As you know, we had a big election this month. Enforcement staff worked very hard getting ready for that, and then during the pre-election period, during the 90 days preceding the election, we received 1,292 complaints and referrals, and 928 of those were received from October 1st to the election date. Included in those numbers were AdWatch submissions. We received 197 AdWatch submissions related to the November election, and 171 of those were received between October 1st and November 8th. We also had our proactive pre-election outreach program. We received 290 referrals for that program. I'll remind you what we do again. We reach out to filing officers in counties and cities throughout the state with a certain population and invite them to participate in the program by sending us referrals of people who haven't filed their statements before the election so that we can attempt to get compliance before the election for these filers. Between the first and second pre-election periods, we received 290 referrals from the participating filing officers. 44 of those were referred to attorneys. So what happens is we have staff who calls and emails, say, hey, you've got this statement you need to file, please file it. Most of them respond to our staff inquiries, but 44 of them did not. And so they were referred to attorneys for further action. The attorneys first, reach out, call, email, try to get them to file. If they don't file within a certain amount of time, then we will pursue either a probable cause report for cases that are short form filers, people who haven't qualified as a committee but still owe a statement, or we'll seek civil action and injunction if it's an actual committee. Of the 44 that went to attorneys, we did not need to seek a civil injunction, that we threatened a couple. And then we did serve some PC reports, but all in all, we had only one who did not file before the election. So we did very well this year, and I'm very pleased with my staff and their extensive efforts going into regarding the November election.
Thank you very much for that. And certainly kudos to the Enforcement Division staff. I know that was a very busy period of time, particularly the pre-election efforts, and that's fantastic success on pre-election. I would also note, I think there were some non-enforcement folks got roped into helping with that as well.
Yes, thank you for reminding me. Yes, it was definitely
Sitting at the table.
it was definitely an all hands on deck situation because we did receive so many things in October, particularly. So we did reach out to other staff, and Sasha included, and we had a lot of help outside to get us over the hump, especially after that first pre-election. That was the harder hitting statement.
I'm curious on AdWatch. Are there any? We've had AdWatch for a while now. Are there any aspects of AdWatch that you, based on this year's election experience, are thinking about tinkering with or changing in any way?
We haven't had our meeting yet where we debrief about the pre-election and how things are going, but we did notice a couple of things that jumped out at us. There continues to be a lot of submissions that turn out to be candidate advertisements. And as you know, candidate ads not everyone needs disclosure. So yard signs, for instance, if it's paid for by the candidates committee, they don't have to include a disclosure. But the general public doesn't necessarily know that. So we can consider doing things like putting up more information on our website for the AdWatch portal. Like if you see X, Y, and Z, disclosure may not be required. Here are the rules, because we have our advertisement charts on our website as well. We could refer folks to those to be able to look and see what is required under those circumstances. And that might help to lessen the number that comes in, because our staff still has to look at each ad, because we do need to determine if it was an independent expenditure, then it did require disclosure. So we can't just look at an ad and say, oh, this was definitely from a candidate. We have to try to glean some information either online or from the person who actually made the submission. But many of the submissions are anonymous, so we don't have anybody to reach out to in that respect. So yes, we would like to make some changes going forward. And I will be meeting with staff to get some of their ideas about how we can make the process a little easier for the public and lessen the impact on our staff, but still be able to look, because there are some that are anonymous. They're sent out with no disclosure, and they needed to have disclosure because it was a committee who disclosed them, and it's important for us to be able to get those complaints and be able to figure out who sent them. But and so we want to balance the factors there, like still encourage people to give us submissions, but ones that we can really make an impact on.
Thank you. And then another question on pre-election outreach efforts at gaining compliance before the election. What is the technical way in which those are ultimately resolved? Like, we contact somebody, Sasha calls them, hounds them, they file their reports, and so do we open up a case and do a streamline? Like, how does that work its way to the system, through the system?
Yes, during the actual pre-election time frame, we don't typically open cases because that takes staff time, and we want them focused on getting the actual filing done. Now, our time period right now, all of these cases or complaints are getting converted into cases, unless there have been a few where we've rejected them because they were referred to us in error, the person didn't actually owe the statement, or the person actually filed. So those, we resolve as rejecting complaint, that particular referral. For the others, we do convert them into cases, and then we resolve them using our Streamline and Warning Letter program.
Do you have an idea, like what percentage go through Streamline versus just get a warning letter?
Our practice right now is that if the statement was filed before the election and there are no other issues, like sometimes there were 24-hour reports that were required, for instance, and weren't filed. If everything that was due was filed before the election, those qualify for a warning letter, and we issue a warning letter as quickly as possible and try to resolve those as soon as we can so that we don't have those sitting around. I don't know what the percentage is between, of these 290 that we received, like how many of them actually qualify for the warning letter, but we do, it's a pretty high percentage because we do get most of the people to file, and many of them we can even catch if they owed 24-hour reports as well. Not every case includes that issue.
Okay, well, just looking, because 290, I think you said you had like one or two people who you had to really threaten to go, but even they filed ultimately. Right?
Yes.
So then setting aside exceptional circumstances, almost all of the 290 would then be getting warning letters. Is that right?
Yes.
Okay. All right. I just want to make sure.
At least that's what we hope.
Right, barring other circumstances. All right. Thank you. Commissioner Baker.
I think this is very helpful. Got to wait for an election to get sort of an update on how this all goes down. My question is, it's just occurring to me while we're listening. So a lot of, triage and intensity and staff, all hands on deck happens in this last several weeks before an election to try to clear out some of these, get compliance, save them from being a whole open case. And it just made me wonder if someone has a similar late period, like a late filing that's not during that time period, are they treated a little bit differently down the road where they didn't, it's not like we're after the semi-annual reporting, we don't similarly have all hands on deck trying to call people and say, hey, I'm just kind of curious about that. The benefit of taking care of it before election days, there's transparent information to the public as quickly as possible. Plus, we're not creating a pipeline of cases that could have easily been resolved. And we don't really do that at other times of year. I'm not sure I would advocate for that. But to make me wonder, if a similar violation happens at any other time of the year, does that mean those cases might be treated differently and they become an open case as opposed to something that could have been resolved pretty quickly? Because maybe we'll change things down the road. Just curious.
Regarding semi-annual statements, we do not have the same type of effort where we have multiple staff members calling a lot of people, but it's a little bit different how we get them too, because we tend to get the referrals more gradually and not in gigantic batches. Occasionally that will happen from filing officers, but for the most part, we get a handful at a time from the filing officers as they're completing their tasks of contacting each filer and saying, okay, you owe this statement, because they won't refer the matter to us if they can get compliance first. So, they go through their steps of trying to get compliance, and then once they have exhausted their efforts, then it gets referred to us. And then we'll do the same thing. We try to get them the compliance initially. And many times we can, sometimes we can't get a hold of them, or, there's difficulties or they don't understand. So we work with each case as is needed. But we do have, then many of the non-filers are resolved through the Streamline and Warning Letter program. And there are all sorts of factors included in there about it, how, when was the statement filed? How late was it? Do they have experience before? Did they raise and spend less than $2,000 for this particular campaign statement? So all of those factors still apply to the other non-filers that come in. The timing is just a little bit different.
Thank you, helpful, and thanks to everyone who did the all hands on deck during the election period.
Any other questions, comments for Chief Brereton? Hearing and seeing none. Thank you, Chief Brereton.
Thank you.
All right, we'll then proceed to our Audits and Assistance Division report. Chief Shaw.
Good afternoon, Chair and Commissioners. My report is as submitted, but I can answer any questions you may have.
Any questions for Chief Shaw on the Audits and Assistance Division report? Hearing and seeing none.
All right.
Thank you again.
Thank you.
We'll move to the Legal Division report. Mr. Bainbridge.
I don't have anything to add to the report. I will acknowledge the people with the hands on deck who helped out enforcement were Edgar and Sylvia from our PrEP program. So they took some time out of creating and administering our new PrEP program to help out with getting some of this compliance. So thank you to them, and thank you to all the Legal Division staff who are similarly busy in the month of October, as you can tell from the numbers, over 900 emails and telephone calls, dealing with people who are frazzled and impatient and up for election and everything that goes along with that. So it's not just the numbers; it's difficult questions and sometimes difficult people that they're dealing with. So we just want to acknowledge them as well. With that, I don't have anything else and can take any questions.
Thank you, Mr. Bainbridge. Any questions for Mr. Bainbridge on the Legal Division report? Hearing and seeing none. Move to the Admin and Technology Division report. Chief Hahn.
I don't have anything to add, but I'm here to answer any question you may have.
Thank you. Any questions for Chief Hahn on the Admin and Tech Division report? Hearing and seeing none. Thank you, Chief Hahn. Executive Director West.
Hello.
Anything to add?
No, nothing happened in the last couple of months. No, I'd like to invite our communications director, Jay Weinranger, to come up and give us a little update on his efforts coming up to the election.
Good afternoon, Mr. Weinranger.
Good afternoon, Chair and Commissioners. Jay Weinranger, Communications Director. I'm here to provide this update on some of our video projects and a recap of our 2022 general election PSA public service campaign. First, with our ongoing partnership with the Video Production Department at Laney College in Oakland, we were able to create a video describing the changes made by the Commission allowing cryptocurrency contributions, the past few weeks notwithstanding, to California political campaigns. The video was made by the same student that made our basic FPPC overview video a year or so ago. So special thanks to Susan Bradley for her work, her creativity, and the contribution to our agency. The video was completed and we were able to put it on our website and push it out on Twitter before November 8th. So that was good. And I think Jesse and IT is going to play that video for us now. The crypto first. I think we have sound. Soothing music and monetary sounds.
I wonder where I can find that.
But we did get the crypto fact sheets referenced, as well as I believe.
Can I help you?
No, just that. For the benefit of our newest commissioner, 2 years ago, we contracted with a local production company to produce a short PSA to show the public how the public can find out who's behind political ads. One was in English, and then we added Spanish language. So we thank Patricia Ballantyne for voicing the Spanish version of that. And do we have those videos? Do we have the sound?
Want to know who's behind these ads?
We're the FPPC, and we can help you find out.
Please stand by. Anyhow, we had those two both in English and Spanish, and they are on our website on the homepage. Our goal was to increase the brand awareness and drive activity to our website. So we again targeted to the demographics of those politically active or interested to various California markets via two of the largest media providers in the state. We also did a Google outreach, and I'll get to that as well. That's substantially less expensive, but also comes with far less delivery in terms of results, generally speaking. The first was from McClatchy, which we also did in the spring. It included not only their media brands in Sacramento, Modesto, Fresno, but also other media such as Yahoo, CNN, USA Today, Washington Post, Reuters, KTLA, TV in Los Angeles, ABC 10 in Sacramento, and other outlets. And with that campaign, we had more than 357,000 impressions and more than 101,000 total views, with a video completion rate of about 64%. So all of that was at or above our target level. Of the 21 cities where this was targeted, Los Angeles, San Diego, and San Jose had the highest views, and the Washington Post and CNN had the highest viewing rates at about 82%. The other media provider was the LA Times, which came in just above our targets. We had contracted for 600,000 combined social, video, audio, and digital video impressions, and we received almost 640,000. And the click-through rate on that was about 1%, which was actually about twice as high as the click-through on the McClatchy for whatever reason, but the results are still good. And finally, our Google Analytics show about 56,000 impressions total. And as we saw in the primary, I think if you recall the presentation back then, most of the people see this on their phone. And just again, demographically, it was interesting. Men 35 and younger and women 55 and older were the top two demos for our video on Google. So all told, that's about 1,050,000 impressions made throughout the state with the PSA from Labor Day through Election Day. And with that, I'll open it up to any questions.
Thank you, Mr. Waringa. Any questions, comments? Great job, as always.
Thank you.
All right, that brings us to our, unless you have anything further. All right, that brings us to our final item, Commissioner comments, proposed future agenda items. I've been taking notes, and Commissioner Wood, I believe, I will frame it this way, that you had, for future agenda item, ideas to address pay-to-play activities by independent expenditure committees. Is that right? All right, then.
I mean, I can say more. I don't know if you want to start that kind of thing in law and policy first or something, but it just seems like, given what I saw this last cycle, the statute as it is doesn't cover all the concerns that we may have over pay-to-play.
All right. Do you have data, or if you have any documentation or data that you can share with Mr. Bainbridge, I think that would be helpful for identifying the timing and the right forum for this discussion to come back to the commission in.
Sure, Mr. Bainbridge, maybe we can hop on the phone at some point and I can tell you what I'm thinking.
Okay. All right, excellent. Thank you, Commissioner Wood. And then I had, at Law and Policy this last month, Commissioner Baker and I introduced several proposed policies to assist the Enforcement Division in prioritizing their work, given the incredible workload that they are operating under these days, and some ideas to improve the efficiency and timeliness of our resolution of those cases. And so that is something that I know will be coming, we intend to bring back to the full commission for adoption in January. Between now and that time, I know myself and others are meeting with Enforcement Division staff to generate their ideas and their thoughts on it. So it will be, the idea will be it is a collaborative process by the time this comes back to the commission in January. that's all I have for future agenda items. Does anybody have anything further? All right, do we have a motion to adjourn? Well, I'll make
I
it.
move to adjourn.
All right,
Second.
all right. Motion and a second. Ms. Linker.
Commissioner Baker,
Aye.
Commissioner Gomez, Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
All right, thank you, everyone. Happy Thanksgiving next week.
Yeah, enjoy.